California Supreme Court upholds classification of delivery drivers as independent contractors. Under a unanimous California Supreme Court decision, drivers that work for companies like Uber and DoorDash are officially considered contractors, not company employees. On Thursday, the California Supreme Court upheld an earlier appeals court decision that affirmed the legality of Proposition 22, a bill that delivery apps spent $200 million lobbying for and passed in November 2020. This bill changed the legal classification of delivery drivers back from company employees to independent contractors. Proposition 22 was a direct response to a 2018 Supreme Court ruling and the subsequent 2019 California Assembly Bill 5, which went into effect on January 1, 2020. It made it harder for companies like Uber and DoorDash to argue that their delivery drivers were independent gig workers. AB 5 had stated that drivers would qualify as employees if the company controls how they perform their job or if the job is part of the company's regular business. At the time, delivery companies got together to file a lawsuit against the state of California, declaring that the AB 5 was unconstitutional. Delivery companies and other proponents of Proposition 22 argue that classifying drivers as contractors is beneficial to these workers because it allows them the flexibility of setting their own hours and schedule within an on-demand structure. Critics of this reclassification have argued, however, that legally making drivers contractors rather than employees lets delivery companies off the hook, especially when it comes to paying out benefits for full-time employees, including paid sick days, health insurance benefits, and the ability to unionize. Since Proposition 22 was approved by California voters in 2020, the legality of the case has bounced around in lower courts. The state Supreme Court decision is likely to be the final say on the matter after more than 4 years of legal deliberation. The decision was lauded by delivery companies. This decision is a huge victory for California dashers and voters. Proposition 22 is here to stay. Liz Jarvis-Jean, Vice President of Communications and Policy, said in a statement, "Today, we celebrate with hundreds of thousands of dashers in California who will maintain access to crucial benefits and protections and to the unique flexibility that draws them to this kind of work. We are pleased that this law is affirmed and this unnecessary legal process is behind us." Union advocates, however, see this decision as not a legal victory. Proposition 22 has allowed gig companies like Uber, Lyft, and DoorDash to deprive us of a living wage, access to workers' compensation, paid sick leave, and meaningful health care coverage. Service Employees International Union California Executive Director Tia Orr said in a statement obtained by Politico, "Today's ruling not only strengthens our demand for the right to join together in a union so that we can begin improving the gig economy for workers and our customers."
Big win for companies such as Uber and Lyft. Today, the California Supreme Court upheld Proposition 22, which allows gig companies to treat their workers as independent contractors. As ABC 10 News reporter Ryan Hill found out, reaction is split.
One DoorDash driver tells me this ruling allows him to take and deliver orders when he wants and needs to.
It's very beneficial.
Igor Stolyarov's been driving
for DoorDash for 2 years. He came to the U.S. from Russia to study accounting and is now at Miramar College.
While I'm looking for some job, DoorDash really supports my life. It pays very good money, rent payments, utilities, and other stuff.
The California Supreme Court making a big decision on how Igor and other similar types of drivers are classified. It ruled Prop 22, which was approved by the voters 4 years ago, would stand. It allows companies like Uber, Lyft, DoorDash, and others to treat employees as independent contractors instead of full-time employees. This exempts them from AB 5, signed into law by Governor Gavin Newsom in 2019. Requiring certain workers previously classified as independent to be paid the same wages and benefits as full-time employees.
I really liked it because I know that I can work whenever I want. I'm my own boss. When I'm working, if I have some urgent stuff to do, I can just stop and do it and then turn back, and DoorDash will not punish me for that. 100% flexibility. I really enjoy Proposition 22.
Some companies and drivers are happy with the state Supreme Court's call on Prop 22. But UCSD professor Alan Jin tells me there's more to unwrap with the court's decision.
It's a mixed bag. The benefits to the drivers and others are that there may be more employment opportunities. There may be the opportunity to work more. But again, they don't get the protections of being a full-time employee.
In a statement, the president of the California Federation of Labor Unions, Lorena Gonzalez, says she's disappointed with the court's decision. She says in part, quote, AB 5 granted virtually all California workers the right to be paid for all hours worked, health and safety standards, unemployment insurance, workers' compensation, and the right to organize. Rideshare and delivery drivers deserve those rights as well. Ryan Hill, ABC 10 News.